will call the next case. Mr. Porter, you get to move tables, apparently. The next case is Macomb County Prosecutor versus the Macomb County Executive and County of Macomb. Another oral argument on the application. Again, 15 minutes per side. Again, you both have 2-minute fire free. Helen, if you would like to reserve your time, you may do so. Just keep track of it yourself, please. And go ahead and proceed when you are ready.
Good afternoon. May it please the court, David Porter here on behalf of Macomb County and its County Executive, Mark Hackle. I'd like to reserve 4 minutes for rebuttal. I understand I need to keep track of my own time. As this court knows, the primary question presented in this case is the one that we just discussed moments ago, and I won't retread any of that ground. I will simply urge the court to reverse the court appeals on this and the statute of limitations ground because it will sow confusion for lower courts, not just in Macomb County, but for counties across the state. Let me first orient the court to the factual setting in which this dispute arose, address the framework that the charter has for addressing this issue, and then I'll move back into the Court of Appeals opinion. This dispute arose because the county prosecutor asked for taxpayer funds to hire 5 private law firms to use as his own mini corporation counsel for general legal advice. Now, the charter framework already has certain provisions that allow the county prosecutor and other countywide elected officials to seek general legal advice from corporation counsel. Section 6.6.5 prohibits the expenditure of taxpayer funds for outside law firms and directs them to use corporation counsel. And in tandem with that provision, Section 7.5.1 imposes a duty upon corporation counsel to provide that legal advice. When corporation counsel either cannot or decides in prudence not to, he can appoint special counsel to provide that representation. The key point here is that under the charter, countywide elected officials like the prosecutor get legal advice in every circumstance, either from corporation counsel themselves or from somebody appointed by them. The Court of Appeals in this case held that although the first sentence of 6.6.5 generally prohibits the use of taxpayer funds, the ordinance in this case was authorized because it was otherwise permitted by law, which is the proviso of the first sentence of 6.6.5. And the law that authorized it or permitted it was the very ordinance that the commission passed appropriating the funds. We think that that's circular, and it defeats the purpose of the word law, as we've just discussed in this past case. And I won't retread any of that ground here, just incorporate them by reference. More to the point, that reasoning defeats the very purpose of Section 6.6.5. If, under the first sentence, the commission could just pass an ordinance that allows the expenditure of taxpayer funds, then the second sentence of 6.6.5 is meaningless. The second sentence is a specific situation in which the commission can appoint outside counsel when the countywide elected official wants to bring an action as a plaintiff to protect the rights, duties, and powers of his or her office. If the commission already has general plenary authority under the first sentence to authorize the expenditure of taxpayer funds for outside counsel, the second sentence is meaningless. It would also sideline corporation counsel from providing legal advice. He has a duty to provide this, either himself or through an appointment under Section 7.5.3. It would defeat the entire framework that we have for provision of legal advice for countywide elected officials through corporation counsel. Now, the genesis for this was a supposed personality conflict between the prosecutor and corporation counsel. Now, there are 2 responses to this, and we've laid them out in our brief. But the first and most important is that whatever personality conflict there may be is legally irrelevant under the charter. And in fact, the charter framework allows or acknowledges that this might happen. If there is a situation in which Corporation Counsel either cannot or decides not to provide the legal advice themselves, he can appoint outside counsel to provide it for him. The important point is that it must be funneled through Corporation Counsel, so that there is oversight under the charter about when countywide elected officials are receiving legal advice and from whom. But I don't want there to be any misunderstanding. There's actually no factual basis for this suggestion that Corporation Counsel is either conflicted or disqualified from providing this legal advice. There is no factual justification for the ordinance in the first place. It was not alleged in the complaint. It was not found by the Court of Appeals. And it's just simply not true. The Corporation Counsel has never denied the prosecutor any legal representation, either through himself, his office, or through outside counsel. It also misunderstands conflict laws, because it is simply not possible to have a conflict in this situation. The prosecutor, when he seeks legal advice for his office, is seeking legal advice as a subunit of county government. There is not two parties, there is only one. So for all those reasons, it's simply not a valid, legitimate basis in which to condone this otherwise unlawful ordinance simply because there might be a personality conflict between the Corporation Counsel and the prosecutor. Now, unless there are any other questions on this, the merits issue, I'm going to move now to the statute of limitations issue. This dispute arose because the countywide elected official, the head of a branch of county government, has the right under the Uniform Budgeting and Accounting Act to bring an action within 60 days of when an executive takes action relating to the enforcement of a budget. And you can bring that action in the Court of Appeals. The rule of decision that we're asking this court to adopt is that an executive takes an action with respect to the General Appropriations Act when he impounds funds. That is, he states unequivocally that he will not disperse the funds for their intended purpose. In this case, the executive impounded the funds on December 8th, 2023, when he stated in no uncertain terms that he would not allow the expenditure of these funds because they were unlawful under the charter. Even the prosecutor thought this was an impoundment, and even the prosecutor thought that this gave rise to a legal action under the Uniform Budgeting and Accounting Act. In early January, he wrote
Is that right? Did he actually impound funds, or he just threatened to impound funds?
He stated that he would not authorize the expenditure of these funds, even if the veto was overridden.
Okay.
So it was not a mere threat. He was actually saying unequivocally, these funds will not be spent under no circumstances.
So I still don't know whether he threatened or he actually impounded funds.
He did not threaten to do that. In fact, this is one of the difficulties when you're talking about impoundment. There is no box you can check that says funds impounded. There's no physical action you can
But
take.
at the time he does this, there's no ordinance either that authorizes it, is there?
There is. The ordinance becomes effective on the date that the budget is adopted, which was in late November of 2023. On December 8th, the executive excised a line item of that ordinance, and several days later, the Board of Commissioners retracted that line item veto and overrode it. But at the time that he did that, yes, there was a budget, yes, there was a General Appropriations Act, and yes, there was something to impound at that time.
Well, the fact that the prosecutor may have had a cause of action stemming from that impoundment, fine, but what about the fact that why doesn't he have a cause of action that accrued when the executive wouldn't sign the contracts?
And so and this is just standard accrual principles right here. If he had an action in late 2023, that is when you're supposed to bring your action. You cannot restart the statute of limitations
Well,
clock.
but something happened in between. The commission overrode the veto, right? Like, so we're not on the same, it's not like, well, I said I wasn't gonna do it, and 30 days later, I lived up to my word, right? He said, I'm not gonna do it, I'm vetoing it, and the commission overruled it, or overrode it.
Mhm.
And maybe he would have had, it's an interesting question, maybe he would have had it from the line item, the time of the veto, but I don't understand why that means then that the action of actually not doing what the commission said he didn't have authority to do, why that's not a cause of action?
So I think the answer is in the content of the executive's message on December 8th. He says, even if you override my veto, these funds will not be dispersed. He could not have made himself more clear.
Could he have changed his mind?
No. He could have, yes, but that's not a reliable basis upon which to create accrual rules. Yes, he could have changed his mind after July 29th. And so that reasoning sort of is self-defeating for the plaintiff in this case, because he could have changed his mind today. The fact is he stated unequivocally, I will not allow these funds to be dispersed, even if you override my veto. And I think that's the important part.
Wasn't in January, wasn't he still trying to kind of work this out, figure out if we could cut out some deal on these contracts?
There were ongoing discussions. I think about it, there was a second issue in this case that was ongoing that they were working out.
But isn't that, the point that, if you can change your mind and then there becomes a moment where it's very clear, okay, now it's clear. It feels very amorphous to be like that you can preemptively veto.
The problem with that is that the executive can always change his mind. And in fact, if you look at what he says on the 29th, he never actually says, I will not sign these contracts. There's no evidence in this record of him ever refusing to sign a contract. He simply states on January 29th, as I said in my veto message back in December, I will not allow these to be dispersed. And even in his own letter, he says, but look, if I'm wrong, and if you can find authority, please let me know. I'd love to sit down and discuss. And it would be, to my mind, it would not be a reliable rule of decision to say that a local official who continues to work in good faith with his counterparts to work things out somehow restarts the clock every single time they engage in those good faith efforts. He made himself very clear in December that he will not allow these funds to be dispersed. And if that is enough to start the clock and to impound funds, then anything that happens after that, which is a mere reiteration of what he says on December 8th, cannot restart the clock. And that's just a general principle of accrual law. Once there's a first injury, that's when the clock starts, and a subsequent injury of the same type cannot restart the clock after that. The difficulty with adopting the Court of Appeals analysis and the analysis offered by the other side is that it would render the 60-day statute of limitations effectively meaningless, because the countywide elected official can continue to present contracts to the executive to have him sign, always, perpetually restarting the clock every single time. We would be constantly coming back to the Court of Appeals. The Court of Appeals is supposed to be a court of limited jurisdiction for claims brought within 60 days of the action relating to the enforcement of the budget, so that we can get certainty and clarity and predictability for the rest of the budget cycle. And allowing the prosecutor or another elected official to continue to come back and sort of resurrect these claims every couple of months is going to lead to chaos and flood the Court of Appeals, with more cases. So unless there are any other questions on this or the other issue, I will reserve the remainder of my time for rebuttal.
Thank you.
Thank you.
If it pleases the court, my name is John Perrin. I'm here on behalf of the Macomb County Prosecutor. I'm going to address the last issue first, because I hope I can dispose of it fairly quickly. When the Macomb County Executive threatens to veto, that means that to veto and threatens that if you override my veto, I'm not going to disperse these funds. If the commission does not override the veto, there's no appropriation. An impoundment, by definition, is the refusal to release funds. Until we finish that process of going through what the charter requires, of the commission taking steps, the executive having the opportunity to veto, and then the opportunity for the commission to override, we don't have an appropriation. This is where I think this all got confused and muddied, but a threat to veto may be an attempt to influence what the commission does, but it is not an impoundment. And Brother Counsel and I both agree that the accrual happens when the impoundment occurs. And the impoundment is an act. In essence, the refusal to release funds. It doesn't require a statement or anything else. The executive could refuse to release funds for a particular contract, but let 4 go through. There's lots of ways that he can impound funds. And that's why the statute says an action, not the action. And to the court's point, and several of the justices pointed this out, there was back and forth. The executive was asking, what's the legal basis? Why is it that you feel that I'm wrong on this? And they had discussions. That's government functioning properly, not dysfunctionally. I don't believe that the statute of limitations issue is really the substantive issue here. And to be clear, I also do not believe that this is an issue of county-wide jurisprudence that has to be dealt with. This is actually very much uniquely a Macomb County issue. Very focal to this particular charter, which, in fairness, I think we all agree could have been written better. There is no definition within this charter of ordinance or law, but I would encourage the justices that the confusion over that concept of ordinance versus law, you can see even in the drafter's attempts in sections 11.1 and 11.2 to explain what laws continued and what ordinances continued. And under sections 11.2, it says laws continued, which is a statutory requirement, a mandatory term within the requirements for a charter. And it says the general laws and local acts of the state. Local acts are ordinances. They're local laws. And that's what we're fighting over, is local laws. The other important things to remember in reading this charter is that the drafters, while they may have been less artful in how they put this together, they gave us a lens, a very specific lens, to look at this document through. And it's contained in section 1.2. And it tells us that this charter should be construed, could be read liberally to effectuate its purpose, which was to give the county the ability to deal with its own problems internally. It didn't need to go to Lansing and ask the legislature to create a statute to deal with a conflict between an elected official, countywide elected official, and corporation counsel. And while my brother counsel suggests that they don't have anything more than a personal conflict, in the Court of Appeals, it was corporation counsel who appeared on behalf of the executive and argued against the prosecutor on these issues. They've been on opposite sides of issues. It is clearly evolved into a personality conflict, but the whole concept of the attorney-client relationship is that it's based on one of trust and confidence. And when that breaks down, that's beyond the statute, that's beyond the charter. That goes to us and our rules of professional conduct and how we're going to deal with our clients. More importantly, though, is brother counsel representing the executive has pointed out or suggested that we should just, if you went to cross out the word law throughout this charter and replace it with ordinance, it would cause all kinds of problems. If I asked the justices to define the word cap, without context, it has no meaning. Are you wearing a cap? Is there a cap on spending? Is this a short word for capital? What does it mean? And without context, the word law in this document has no meaning. So we take the lens that the drafters gave us, broad, liberal, flexible understanding of what this document is for, and then we read this in context. And you'll see that when the executive's brief refers to section 6.5, they almost continuously eliminate part of the sentence. The countywide elected officials provided for in this article shall not cause expenditure of taxpayer funds for legal counsel unless permitted by law. That is a very specific restriction, It is within a compartment of this charter, Article 6, which has nothing to do with Article 4. Article 4 is the commission. If you were to look at section 10.8 in the charter, we're going to see the mirror language of the statute on permissive terms for charters that's contained in MCL 45.515C. And what it tells us is the county may perform any function or service and establish or maintain any facility not prohibited by law. The elected officials have a prohibition, but the commission as the legislative body does not. And what's also interesting is that this concept of permitted by law and whether the prosecutor needs a law in order to be able to ask the commission for an appropriation is just incorrect. It misconstrues the process by which outside legal counsel or legal counsel on civil matters can be brought into the county to assist on what I like to refer to as risk management issues. Civil matters that have not arisen to the level of litigation, but we're trying to avoid that. And if you actually read MCL 49.71, that statute specifically says that the board, by a majority, may employ an attorney to represent the county in civil matters. Civil matters, it doesn't say civil litigation, it says civil matters. This is a power that is vested in the board. They have this ability. What's also interesting is that, and you can see this in Corporation Counsel's interpretation of the charter, which fueled much of this argument. In section 7.5.1b, it states that Corporation Counsel shall be chief legal counsel to the county and represent the county, the executive, the commission, the department heads, which includes countywide elected officials, and agencies in civil legal matters, it does not say as defendants, affecting the county except as provided by charter law or ordinance. In other words, in that broad interpretation of the charter and under the broad legislative powers of the Board of Commissioners, they can, by ordinance, put a different lawyer in place instead of Corporation Counsel. And it doesn't require a conflict of interest or a conflict of personalities. They have broad legislative powers, and if this is a matter that affects the county and is of local concern, they can act. That's the way the charter is written. Granted, there is definitely redundancy in many of these sentences, but you'll also see references to the phrase practice of law. Are we going to insist that that means only the practice of state statutes? Permitted by law, in many instances, is simply a term of art. And am I permitted by law to park in handicap spaces? No, I'm not. But there's an ordinance that makes that unlawful. We understand, and the Court of Appeals understood, that law is an aggregate term. They did not make a decision that law and ordinance were the same words. What they did, which was appropriate, was they looked at preemption. They studied the statutes that were presented to them. They said, these statutes don't occupy the entire space, and there's room in here for local legislation. Legislation is law. That's what it is. This is a very strained way of reading this charter, and it's strained in such a way that it does not provide the purpose for which the charter was created. So unless there's questions.
Counselor, I was just wondering, 6.6.5, does that limit what, a lawyer can be used for the executives or the county electeds?
I don't think, I think, Your Honor, that 6.6.5 allows public funds from the commission through an appropriation for purposes that benefit the county. And in that particular instance, I believe the focus is primarily civil matters, matters other than criminal matters, which is the prosecutor's niche. He knows that area.
Thank you.
Are there any other questions? Thank you.
Thank you. Mr. Porter, you have a little over 2 minutes.
Three quick points. First, the executive in this case did not threaten to issue a veto. He actually did veto this ordinance, and he made clear on December 8th that he would not disperse these funds under no uncertain terms. Second point is the argument that Section 6.6.5 does not apply to the commission and only applies to countywide elected officials. That would render the first sentence meaningless. It's unnecessary because state law and another provision in the charter already prohibit the countywide elected officials from expending funds that are not authorized by an appropriation. That's MCL 141439, as well as section 6.6.4 of the charter. Subsection C says that they are subject to the expenditure approvals by the commission. So this reading of the first sentence of 6.6.5, that it only applies to countywide elected officials and not the commission, would make that first sentence unnecessary. It would also render the second sentence meaningless for the reasons that we've already stated. Finally, the notion that this is a question about preemption, and the question is whether or not there's a prohibition in some statute somewhere. The problem with that argument is it ignores that we're interpreting a charter. The charter is what allocates the powers of county government in Macomb County. And the charter is very clear. You cannot expend taxpayer funds unless it's permitted by law. So the question is not whether it's prohibited by law, but whether it's permitted by law. And everyone agrees that the Civil Council statute, the Governmental Tort Liability Act, the only two statutes that have ever been cited in this context, do not authorize the expenditure of these funds. The only question is whether this is an ordinance. This ordinance authorizes the expenditure of these funds. And for the reasons that we've already stated, the answer is no, because it's not a law. So unless there are any other questions, we'd ask this court to reverse and remand for entry of judgment in the defendant's favor.
Thank you very much.
Thank you.
All right, the case will be submitted and the court is adjourned. We will be back tomorrow morning for the second day of the call at 9:30. Thank you very much.